through various judgments. So I just pulled whatever I could remember. One of the most important ones is Hussain Ara Khatun versus Home Secretary of Bihar. That's a 1979 judgment. It's said that the right to fair trial is a fundamental right. It's an aspect of right to life, and nobody can be denied of it. And while if somebody does not have the right, has legal counsel, a right to free legal aid exists. It's the state's duty to provide free legal aid so that there is representation to the accused and the suspects in trial and in appeal. One of the most important judgments in India is the D.K. Basu versus State of West Bengal. So Supreme Court essentially laid down a guideline of 8 to 9 points, which said that the police officer has to identify himself, there has to be batches present, there cannot be interrogation in dark rooms, there cannot be custodial violence, so on and so forth. So D.K. Basu propounds the right to life, Article 21, and safeguards the rights of accused and suspects during investigation and trial. One of the most important, other important cases called Sunil Batra versus Delhi Administration. Again, one of the most important cases, and it says that fundamental rights, which are prescribed in Article 14 to 25 of the Constitution of India, they do not flee when a person enters the prison. So there has been a large movement for prisoners' rights as well, and there is therefore the right to dignity even in prison. And this is another area of law which is still being propounded and expounded in India. Onni Krishnan versus State of AP is again an important right, which says that there is a right against solitary confinement, there cannot be delayed execution, there is a right against public hanging, and therefore all the rare cases in India where death penalty is given and there is an execution by death, it is a private hanging or it's a non-broadcasted hanging. It happens in prison, only a couple of people present there. And another more important thing is right against handcuffing. So if accused is being presented in court from between say the investigation and the police towards the courtroom, even if there's a short walk there, a person cannot be handcuffed. He has a life, the person has the right to dignity, has the right to life, and therefore it is inhumane to do so. And apart from that, there's the right to medical assistance even while being incarcerated. Now there is I just have some fleeting thoughts to conclude. Is one of the most important cases very recently I had a chance to be part of was the constitutional challenge to sedition. Section 124A of the Indian Penal Code was brought in as a mechanism to stifle protests, to stifle the Indian freedom struggle, the movement. And this was again a colonial weapon used against every leader in India, be it Gandhi, be it Ambedkar, be it Patel, or anybody and everybody, be it Bose. And therefore, sedition is one section or one offense which has always been this troublesome figure. 2 months ago, in the case called S.G. Vombatkare versus Union of India, Justice N.V. Ramana, who I have the opportunity to work with, passed an order which said that, which essentially in a precarious situation to sum it all, would state sedition till the time the parliament does not have the opportunity to reconsider the section, since it's a colonial trait and it may be called as unconstitutional. It has been stayed or it has been decriminalized. Though it's on the statute books, the effect of that has been nullified. As I already talked about, the jury system has already been abolished. Again, this is some India has been moving towards decolonization. There has been recent trends about making the system Indianized, or bringing more elements of tradition and bringing more elements of India into the judicial structure, especially the criminal justice system, so that it's more transparent. There's less pendency. Clearly, with the high amount of pendency, something is not working, or we need something which is way more towards the culture, towards the people, towards the country, and therefore the new movement in India is moving towards decolonization of the criminal justice system. There's a new advent of new technology. There's something called the FASTER model, which is developed by the Supreme Court. So what the administrative section or what the judges of the Supreme Court found was, though there were bail orders and judgments passed by the judicial officers or the judiciary, by the time they were transmitted to the jail and communicated to the prisoner and to the prison officials, there was a significant delay, and therefore there was unnecessary incarceration, sometimes even for weeks. And therefore there's a new faster system introduced 2 months ago, where there has been a optic fiber network introduced between every judicial complex to every prison complex. Every member of that chain, by a click of a button, gets instructions as to prisoner names, details of the case, and therefore that is another step to introduce a next higher degree of introduce technology to improve criminal justice system and how the criminal system is today. And apart from that, we always have there's a new system where there is a translation of judgments into regional languages. It's I think fairly known that India is a country of diversity, and therefore we have a lot of languages, and therefore there's another step towards even towards victim rights or accused rights, where people are not most conversant with English, and they don't need to be. Though English comes again from a colonial mindset, translation of judgment into regional languages is again an attempt to offset that, so that everybody has their own understanding of what is happening to them or with them. And there are many more which I can take, but I think I've already exceeded my timeline. So I think we're going to take the Q&A later. So that was my presentation. Thank you so much.
Thank you so much, Mr. Kostup Sakawar, for your great presentation about how the implementation of the criminal law system in India. Thank you very much. Now, please allow me to move to the next session. I would like to remind participants that if you have a question, you can type in the chat box. And the present link for this webinar is already on chat. Thank you. Ladies and gentlemen, let's go to our next speaker, the only woman speaker on this international webinar. I'm going to read her profile first. Her name is Dr. Esti Royani, S.Pd, M.Pd. She is a lecturer, lawyer, mediator, researcher, and writer. Her educational background is third diploma at English Department, Mula Warman University, Bachelor degree of Education at English Department, Widyagama University, Master degree of Education at English Department, Mula Warman University with cum laude predicate. Bachelor degree of Law at 17 Agustus 1945 University Samarinda, and Master degree of Law at Merdeka Universitas Malang, UNMER, with cum laude predicate. And she got her doctoral degree of Law from Unisula. So she has two kinds of educational background, in English and law. So besides that, she has a lot of experience in education since 29. It's almost 13 years. Her publication is about law issues and others. The last publication is about shifting customary inheritance laws in Bali regarding the position of inheritance daura that presented at the International Scientific Research Congress last April 2022. And as a writer, she has 6 books. On this 2022, she provides 2 books with title Student Speaking Skill and Buku Panduan Sikat Kuasai TOEFL. Besides that, in the middle of this year, she has a hypnotherapy teaching. She has hypno teaching workshop and certified motivator. All right, I'm going to invite her. Hello, Mrs. Esti Royani. Assalamualaikum. Happy to see you. Your microphone still mute, ma'am.
Can you hear me?
Yes.
Okay.
Hello. Hello, Mrs. Esti.
Hello.
Happy to see you.
Yeah, nice to meet you. Thank you very much because this is the last presenters. So yeah, I would like to start. Is it okay?
Yes, please.
Good note in Indonesia because in Indonesia, yes, still noon. And then good morning in India. I'm Dr. Esti. I'm the lecturer, advocate, and mediator, researcher, and writer. Okay, the first time I would like to say the Honorable of the leader Awang Long School of Law, Dr. Esti Tamwi. And then the second is the Honorable of Advocate Kaustup Sakawar, LLB, B.Ph. from Bar Council of India. And also the Honorable of Dr. Kadarudin from Makassar. Okay, allow me to introduce myself that you know that the moderator already explained about me, and thank you a lot for this chance. This conference title is about Indian and Indonesian criminal law system, listen learn. So the first presenter, Dr. Kadarudin, already explained about Indonesian criminal law, and then Mr. Kaustup also explained about Indian criminal law. So for me, I will explain a little bit combined between Indian and Indonesian criminal law. For introduction, as we know, there are two of the meaning of legal system. The first one, we should know about the meaning of a system, and the second one, we should know what's the meaning of law. As we know, the system is a unit that is built with component of its system that are mechanically functional to achieve the goals of the system. So we want to reach the goals of the system. So the meaning of the law is there is a set of rules in form of regulation and regulate human behavior in life. So conceived and binding content, prohibition and order that must be obeyed, and their sanction is the violate them. So there is we should be obeyed in this case. So the meaning of law. So also a system of law, we can conclusion that a unified system composed of the integrity of the various components of the legal system. For this term, there is a function is bound a unified relationship that is interrelated, dependence, influencing, and that the moving also if the only of or if the only one possesses that is the process of the legal system. So the goal is in order to realize the purpose of law. And we should know that in era Indonesian independent days, we avoid the legal vacuum. It's why we use based on article number 2 of the Transitional Rules of 1945. So according to law number 1 of 1946 was promulgated, that confirmed by law number 8 of 1955. It became changed, the first law number 18 of 1960 that is concerns about the maximum number of fines, that especially in criminal code. We can say that KUHP in Indonesia in Bahasa. And also the second is law number 4 of 1976. That is concerning the editions of probation regarding aphasia. And how about the system of criminal law in Indonesia? So actually we have two kinds system of criminal law in Indonesia. The first one we can say criminal law book in KUHP, and the second one is a customary criminal law. So we have criminal law book at all, we can say in Bahasa KUHP, that is actually they from Netherlands, and that is widened. But how about the customary criminal law? They from local customers. So that is from the society from Indonesia, real Indonesia, that unwritten. Okay, for these terms, we should about the kinds of legal system. There are 4 kinds of legal systems. Actually, the first one, continental European legal system. The second one, the Anglo-Saxon legal system. For the first one, continental European legal system, there are five ingredients of that. That's growing in European countries, and there is the